Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Have you ever found yourself sifting through complex documents, maybe a court judgment, and wishing someone could just translate the essential takeaways into plain English?
Yeah. Or maybe you're curious about how big companies navigate the tricky waters of intellectual property disputes, looking for that strategic edge.
Exactly. Well, you're in the right place. Welcome to the Deep Dive, your ultimate shortcut to being truly well-informed, cutting through the jargon, and getting straight to the crucial insights.
We try our best.
Today, we're embarking on a fascinating deep dive into a recent judgment from the High Court of Delhi. This case involves a patent application appeal, and it's a perfect example of how courts provide pathways for innovation, even when initial applications, hit a snag.
Right.
You, our dedicated listener, shared this court judgment with us, and our mission is clear: to extract the most important nuggets, the surprising facts, and the strategic maneuvers, all to help you understand the challenging, often dense world of patent law.
Exactly. And patent law can certainly seem like a dense maze at first glance.
It really can.
But what's truly illuminating about this particular case is how clearly it illustrates the judicial approach to amending patent claims and handling appeals. It offers some vital lessons on legal strategy and the flexibility available within the Indian patent system.
So potential aha moment.
There's a definite aha moment
Yeah.
potential here, yes, especially for anyone trying to protect their own innovations or navigate similar legal challenges.
Okay, let's unpack this judgment right from the top. Before we get into the story, what are the fundamental details that mark this particular case, the identifiers?
Absolutely. Think of this as the case's unique identifier, its legal fingerprint, if you like. We're looking at case number CA-COMM.IPD-PAY 19-2022.
Okay.
And that also includes associated applications IA 104522022 and IA 350452024. Quite a few numbers there.
Right. And the court?
The judgment was handed down by the High Court of Delhi, located right there in New Delhi.
And when was this?
July 7, 2025. So fairly recent in legal terms.
Got it. And the judge presiding?
Presiding over this matter was the Honorable Miss Justice Mini Pushkarna.
Okay. And the parties involved? Who is appealing?
The company bringing the appeal, the appellant, is Albemarle Corporation. They're incorporated in the United States.
Albemarle Corp., U.S. company. And who were they appealing against?
On the other side, defending the original decision is the Controller of Patents, the government body, essentially.
Right, the patent office. And who are the legal heavyweights stepping into this arena for each side? The lawyers.
Good question. For Albemarle Corporation, Mr. Ankush Verma was the lead counsel, supported by quite a substantial legal team listed in the judgment.
Okay.
And on behalf of the Controller of Patents, Ms. Anupa Pardwaj served as the senior government standing counsel, assisted by Mrs. Muskan Narang.
So experienced teams on both sides.
Definitely. The presence of these seasoned legal teams really underscores the high stakes involved in these kinds of intellectual property disputes.
So now that we know who was involved, what's the story here? How did Albemarle Corporation, this U.S.-based company, end up appealing a patent refusal all the way to the High Court? Give us the key facts and the timeline leading up to this judgment.
Okay, well, the journey to the High Court for Albemarle began quite a while ago. They originally filed their Indian patent application number 2897 LLNP 2012 back on April 4, 2012.
2012. Wow, that's a long process.
It certainly can be. The invention they were trying to protect was titled, and it's a bit of a mouthful, Solvent Systems Having No Flashpoint and Methods Using Such Solvent Systems for Dissolving Rigid Polyurethane Foams.
Okay, yeah, a mouthful, but clearly something with significant industrial application if it's about cleaning polyurethane foam. Sounds useful.
Precisely. Very technical, specific innovation. Now here's where it gets challenging. Fast forward quite a bit to May 12, 2021.
Right.
And the Controller of Patents refused their application under Section 15 of the Patents Act.
Section 15, what does that generally cover?
Think of Section 15 as kind of the gatekeeper for patentability based on the examination report. It gives the controller power to refuse if objections aren't met.
Okay. And why did they refuse it? What were the grounds?
The refusal was based on three fundamental grounds. First, the invention allegedly lacked novelty, meaning it wasn't truly new or unique compared to existing knowledge. Specifically, they cited an earlier document labeled D4.
Lack of novelty.
Okay. Second, it lacked an inventive step when viewed against a combination of prior documents, D1 through D4. This means it wasn't considered a significant, non-obvious improvement over what was already known.
Right, not just new, but clever, too.
Exactly. And finally, it didn't meet the enablement requirement under Section 10.4 of the Patents Act.
Enablement, what's that about?
Enablement means the patent description didn't sufficiently explain how to make or use the invention, clearly enough for someone skilled in the field to replicate it.
Yeah.
So basically, they said the instructions weren't good enough.
So they faced some pretty serious objections right from the start. Novelty, inventive step, enablement, the big ones.
The trifecta, almost, yes.
What kind of back and forth happened before this outright refusal in 2021? Was there much discussion?
Oh, yes. The process leading to that refusal was quite drawn out, demonstrating Albemarle's persistent efforts. The first examination report, or FAR, which is the Patent Office's initial list of objections, was issued way back on October 26, 2017.
2017, okay.
Albemarle then submitted a detailed response in March 2018. They continued to engage, attending multiple hearings, one in October 2020, another in February 2021.
So they were definitely trying to address the issues.
Absolutely. And they filed several rounds of written submissions too, October 2020, November 2020, March 2021, trying to persuade the controller.
But despite all that, refusing.
Despite all that, the application was still refused. And that, naturally, led Albemarle Corporation to file this appeal under Section 117A of the Patents Act, challenging that refusal order.
And this is where the story takes a fascinating turn, right? Something pivotal actually happened during the appeal itself.
Indeed. This is where it gets really interesting from a strategic perspective. While the appeal was underway, pending before the High Court, Albemarle Corporation made a very specific move. They filed an additional application, IA No. 350-452-024.
Another application. What was this one for?
This application was to introduce what's called an auxiliary set of claims.
Auxiliary claims. Like a Plan B.
Exactly like a Plan B. It's essentially a narrower, alternative set of claims they hoped would be more acceptable. What they aimed to do was significantly restrict the scope of their patent application.
How so?
Instead of the broader solvent system, which was the focus of their original main claim, they wanted to narrow it right down, specifically focusing on the process aspect for cleaning polyurethane foam from an article.
Ah, okay. So moving from the solvent,
Yeah.
to the how, the clean the process.
Precisely. And this strategic move, introducing these auxiliary claims during the appeal, is where the core legal issue of the entire judgment really emerged. It shifted the focus dramatically.
That's a crucial strategic pivot.
Yeah.
So even though the initial refusal was based on serious grounds like novelty and inventive step,
Right, and enablement.
what was the actual core legal question the High Court ended up deciding in this specific appeal? It sounds like the focus shifted quite a bit.
That's a very perceptive observation, and it highlights a key strategic choice by Albemarle. While the initial refusal by the controller of patents was based on those grounds you mentioned, lack of novelty, inventive step, and enablement, Albemarle Corporation actually did not press their challenge to that original refusal order on those specific merits during the appeal.
Really? So they didn't argue the original decision was wrong on novelty or inventive step?
Essentially, no. They chose not to fight that particular battle directly in the High Court at this stage. It seems like a calculated decision.
So they didn't concede, but they strategically changed the game, moved the goalposts.
Precisely. Instead of fighting the original objections head-on, they shifted their focus entirely. The primary legal question that the High Court ultimately needed to resolve was whether Albemarle Corporation could be allowed to amend their claims, specifically by introducing this auxiliary set of claims at this late stage of the proceedings, the appellate stage.
So it became a procedural question. Can you even do this, change your claims during an appeal?
Exactly. This wasn't about whether the original invention was novel or inventive anymore, not directly anyway. It was about the procedural right to change the scope of what they were trying to patent mid-appeal.
Yeah.
That truly became the central pivot of the entire judgment.
Okay, so they didn't fight the initial refusal directly, but instead pushed to amend their claims. What was Albemarle's main argument for being allowed to introduce these new, narrower claims, especially at the appeal stage? This sounds like a strategic retreat to a more defensible position.
That's an excellent way to frame it, as strategic repositioning to clear a path forward. Albemarle's main argument centered on the idea of facilitating an expeditious disposal of the matter.
Meaning speeding things up, helping the court decide faster.
Kind of, yes.
Oh, yeah.
Helping resolve the case efficiently. They submitted that the auxiliary claim set was filed precisely for this purpose. The crucial part of their argument was that these new claims significantly restricted the scope of their patent application.
They really hammered that point home.
Yes. Instead of claiming a broad solvent system, which was their original claim 1, a solvent system produced by combining components, their proposed auxiliary claim 1 was explicitly narrowed to a process for cleaning polyurethane foam from an article. They highlighted this difference very clearly.
So essentially, they were trying to make it easier for the patent office and the court to potentially approve by making the invention less ambitious, more specific.
Exactly that. And critically, they strongly asserted that the Patents Act itself does not impose any express bar on amendments during appellate proceedings. This is a core legal point for them. There's nothing in the law saying you absolutely cannot do this.
Oh, wait, that's a strong argument. What else?
And crucially, they argued that their proposed amended claims met several vital criteria under the Act, specifically Section 59, which governs amendments. They argued that changes reduced the scope. They did not introduce any new matter that wasn't already fully disclosed in the original patent specification.
So no sneaking in new inventions.
Right. And importantly, that the amended claims fell wholly within the scope of the originally filed claims. That last point is vital. It means the narrowed claims were still encompassed by what they originally sought to protect, just in a more focused way. It wasn't something entirely different.
And I imagine they had some legal precedent to back this up, to show this kind of maneuver was acceptable, some previous cases.
Yes, they absolutely did. They relied on what they described as a well-settled legal position. They argued that case law shows that amendments which narrow down or restrict the scope of claims are generally permissible.
Why is that generally allowed?
Well, the rationale is that such amendments help address objections like the ones Albemarle initially faced on novelty and inventive step, or they can facilitate the ultimate grant of a patent. It's seen as constructive.
Makes sense.
The condition, of course, is always that these amendments must remain within the bounds of the original patent specification and the originally filed claims. You can't broaden things or add new stuff. Their strategy was clearly to refine and streamline their application to remove the specific grounds for objection, rather than trying to invalidate the original refusal on its merits.
And what was the patent controller's counterargument? Did they just roll over and agree with this strategy of amending at the appeal stage?
Oh, not at all, no. The respondent, the controller of patents, took a firm stance that was quite different from Albemarle's. Their argument was pretty straightforward, actually.
What did they say?
They contended that no amended claims can be allowed at the appellate stage. Full stop.
Just a flat no.
Pretty much. They essentially argued that once a case reaches the appeal stage, the claims are fixed as they were decided upon by the controller. You can't introduce new versions or significantly alter them at this point. It's too late.
And did they address the original refusal reasons too?
Yes, they also used the opportunity to justify the initial impugned order, the refusal. They defended the original decision to reject the patent application on those grounds of lack of novelty, inventive step, and enablement. So while Albemarle pivoted to the procedural argument about amendment,
The controller wanted to stick to their original fight.
exactly, the controller wanted to uphold the finality of the earlier decision and the original substantive grounds for refusal. They weren't keen on revisiting it based on new, narrower claims.
So the stage was set. Albemarle pushing for flexibility to amend, the controller arguing against it, saying it's too late. What was the High Court's verdict on this pivotal amendment question, the very heart of the appeal?
The High Court's decision on this crucial issue was quite clear, and it represented a significant win for Albemarle Corporation's strategy here. The court allowed IA Now 350452024.
Allowed it, meaning
Albemarle's application for filing those auxiliary claims was granted. Consequently, that narrower auxiliary claim set was officially taken on record as part of the proceedings.
So the amendment was accepted by the court? Wow.
What did that mean for the appeal itself and the original refusal order? Did they just overturn the refusal?
This is a very important distinction. The appeal itself was allowed, but only to the extent that these amended claims were accepted by the court.
Okay, so allowed in part.
Sort of. Crucially, the court did not interfere with the merits of the original refusal order dated May 12, 2021.
Why not?
Because, as we discussed, Albemarle deliberately chose not to challenge that original refusal on its substantive grounds, novelty, inventive step, etc., during the appeal.
Ah, right. They changed the playing field. Exactly. So the court didn't need to rule on whether the original refusal was correct. Instead, by accepting the amendments, the court effectively revived patent application number 28897ELNP 2012.
Revived it. That sounds like a second chance, a real lifeline for the applicant.
It absolutely is. It's quite significant. The matter was then remanded, which means sent back, essentially to the patent office.
Back to the controller they were just arguing against.
Back to the controller, yes, but for fresh consideration of the patent application. But critically, this fresh consideration is specifically in view of the amended auxiliary claim set.
So they have to look at it again, but only based on the new, narrower claims.
Precisely. The controller was also directed to complete this re-examination expeditiously within a period of 6 months. So the Patent Office now has to review the application under its new, narrower scope rather than the originally broader claims that were initially refused.
That's a very pragmatic outcome.
It really is. It's a pragmatic approach focused on potentially getting a valid invention protected, even if the initial claims were problematic.
This is key. Why did the court decide to allow these amendments at such a late stage? What was their reasoning, especially given that the controller argued so strongly against it? This feels like a very applicant-friendly decision, offering quite a bit of flexibility.
You're right, it is a crucial point, and the court's reasoning provides significant clarity for patent prosecution in India. The foundational reason, the starting point for the court, was that they found no specific provision in the Patents Act that explicitly bars amendments at the appellate stage.
So the law doesn't say you can't.
Exactly. There's no sentence in the Act saying, "Thou shalt not amend on appeal." This was a powerful statement. The court then pointed to Chapter X of the Patents Act. Think of it as the chapter specifically dealing with changes to patents and specifications.
Okay, Chapter X.
Within that chapter, sections 50 to 59 are the key guides for amendments. These were the sections the court focused on.
And what do those sections tell us about amendments later in the process?
Well, Section 57.3, for example, allows for an amendment application to be made even after the grant of a patent.
Even after it's granted?
Yes, suggesting a general flexibility for amendments throughout a patent's life cycle, not just during initial examination. And perhaps even more compellingly, Section 58.1 allows for amendments to a specification in proceedings before the High Court for the revocation of a patent.
So even when someone is trying to cancel a patent, amendments might be allowed?
Correct. This clearly demonstrates that the legislature intended for a certain degree of flexibility for amendments, even at advanced judicial stages like appeals or revocation proceedings. It's not locked in stone early on.
So it's not just about the initial examination. It's about the entire life cycle of a patent potentially involving amendment.
Exactly. But, and this is a big but, the court emphasized that the key requirement for any amendment, whenever it's proposed, is that it must fulfill the conditions laid out under Section 59 of the Act.
Section 59, that sounds important.
It's the critical test, the gatekeeper for amendments. Section 59 mandates a few things. Amendments must generally be by way of disclaimer, correction, or exclamation.
Disclaimer meaning?
Giving up part of a claim, essentially narrowing it. Crucially, amendments cannot claim or describe matter not in substance disclosed or shown in the specification before the amendment.
Right, the no new matter rule.
The absolute no new matter rule. You can't add something you didn't mention originally. And, equally important, any amended claim must fall wholly within the scope of a claim of the specification before the amendment.
Meaning it has to be narrower or at most the same scope, but definitely not broader.
Precisely. It has to be encompassed by what was originally claimed. It must be narrower or fit within the original boundaries.
And how did Albemarle's auxiliary claims measure up against these strict criteria of Section 59? Did the court think they passed the test?
Yes, the court carefully examined this. It specifically noted that Albemarle's amendments clearly reduced the scope of their claims, moving from the solvent system to the specific cleaning process.
Okay, so that fits the disclaimer or narrowing idea?
Correct. The court found they were not introducing new matter. Rather, the amended claims were effectively a narrowed version of the original claims. They were wholly contained within the original disclosure.
Makes sense.
And the court explicitly stated that it's a well-settled position in law referencing previous cases that amendments which narrow or restrict the scope of claims to address objections or facilitate a patent grant are permissible, provided they adhere to the original specification and claims and meet the Section 59 tests.
So because Albemarle's changes checked all those boxes under Section 59?
Exactly. Since Albemarle's proposed amendments met these strict criteria under Section 59, and because there was no express bar in the Act preventing amendments on appeal, the court found them permissible. The logic was quite clear.
What legal foundations did the court stand on for this decision? Were there specific laws or previous cases that guided them beyond just analyzing Section 59 itself?
Yes, the court was very explicit about the legal framework and the precedents that informed its decision.
Yeah.
The primary legislative backbone, of course, is the Patents Act in 1970 itself. Beyond Section 117A, which, enabled the appeal itself, and Sections 15 and 10(4) that were the basis for the original refusal, though not decided on appeal.
The core provisions were...
The core provisions that determine the amendment's permissibility were, as we just discussed, Sections 57, 58, and crucially Section 59. The court's detailed analysis of Section 59's criteria requiring amendments to be by disclaimer, correction, or explanation, not introducing new matter, and falling wholly within the scope of prior claims was absolutely fundamental to the reasoning.
And which specific judicial decisions, which precedents did they lean on to support this interpretation, setting this standard?
The High Court relied heavily on a few very recent and pertinent precedents from its own jurisdiction, the Delhi High Court. First and foremost, they cited Société des Produits, Nestlé S.A. versus Controller of Patents and Design, and another. That's a 2023 case.
Nestlé, okay. What did that establish?
That Nestlé case was pivotal in establishing that there is no specific bar for amendment at the appellate stage under the Patents Act. It really seems to have paved the way for the flexibility we see applied in Albemarle's appeal.
So that case directly addressed the controller's main argument?
It certainly appears to have. They also relied on Nippon A&L Inc. versus Controller of Patents from 2022.
Nippon, got it.
And W.R. Grace & Co. Con versus Controller of Patents, another 2023 case. Both of these precedents confirm the principle that narrowing amendments, the kind Albemarle proposed, are indeed permissible under Section 59.
Okay, so a consistent line of recent cases.
Yes, these cases collectively provided a robust legal foundation for the court to allow Albemarle's proposed amendments, reinforcing their interpretation of Section 59 and the lack of an explicit bar on appeal stage amendments.
In many significant legal cases, we sometimes see judges disagreeing or offering slightly different perspectives, perhaps in a dissenting or concurring opinion, adding extra layers or disagreeing entirely. Was there any such nuance in this judgment?
That's a very perceptive question. As you're right, those opinions often provide additional layers of insight into complex legal matters.
Yeah.
They can be really revealing.
So did we see that here?
However, in this particular judgment, the source material indicates that there was no dissenting or concurring opinion, none mentioned at all.
Ah, okay.
The judgment was a single, unanimous decision rendered by Honorable Ms. Justice Mini Pushkarna.
So a clear, unified stance from the court.
Exactly. It means the court's reasoning and ultimate decision on the permissibility of amendments at the appellate stage, under the specific conditions outlined, was a unified position. No disagreement recorded.
So let's zoom out. What does this all mean for you, the listener, maybe someone working in R&D or advising innovators or just interested in the broader context of intellectual property and patent law? What's the ripple effect of this decision? What's the significance?
Well, this judgment carries significant implications, and it definitely strengthens several important principles within Indian patent law. Firstly, and maybe most importantly, it powerfully reinforces the concept of flexibility in patent prosecution.
Flexibility being key.
Absolutely. It makes it clear that Indian patent law provides substantial room for applicants to refine and narrow their claims, even at the appellate stage. It signals that the system isn't necessarily forcing them to restart or completely abandon their application if the initial broad claims face objections.
So it's truly not a one-shot-and-you're-out system, as you said earlier.
It really reinforces that, yes. Which leads to the second point. It provides a clear strategic pathway for applicants.
How so?
If you, as an applicant, face objections related to novelty or inventive step on your broader claims, this decision confirms you have a viable route to potentially overcome those objections by narrowing the scope of your invention later in the process, even on appeal. This can save immense time and resources compared to filing entirely new applications or fighting the original refusal tooth and nail.
That sounds incredibly valuable, practically.
It is. Thirdly, it also highlights the judicial facilitation role of the courts. The High Court here demonstrated a willingness to facilitate the appropriate examination of patent applications, instead of adopting an overly strict procedural approach that might just block amendments outright.
They looked for a way forward.
They opted for a more pragmatic stance, particularly when the amendments simplify or clarify the scope of the invention and meet the legal tests. It shows a focus on substance over pure procedure sometimes.
And what about Section 59, which we discussed as the central test for amendments? How is that impacted?
This decision really puts a spotlight on Section 59 of the Patents Act. It underscores that this section is the critical governing principle for all amendments, whether they happen before the controller or during an appeal before the High Court. It acts as the main gatekeeper.
The rule book for changes.
Precisely. Ensuring that changes don't introduce new subject matter, don't broaden the claims, and remain within the original disclosure. It reinforces its central role.
Okay. And the last point.
Finally, it sets a clear precedent for remand, for merit review in these situations. The court didn't just allow the amendment and say, okay, grant the patent now. They sent the case back to the patent office for re-examination.
So the experts still get to check the narrowed invention.
Exactly. This means the Patent Office gets to re-examine the application based on the amended, narrower claims, ensuring that even this refined version still meets all the substantive requirements for patentability, like novelty and inventive step within its new scope. It effectively gives the applicant a crucial second chance, but still requires proper scrutiny.
Okay, that makes a lot of sense. It balances flexibility with rigor. If there's just one thing, one core insight you should carry forward from this deep dive, what is it? The absolute key takeaway.
The single most important takeaway, I'd say, is this. The Indian High Court explicitly permits and arguably even encourages the narrowing of patent claims at the appellate stage. This allows applications to be re-examined on a more focused basis, even after an initial refusal.
So that door isn't necessarily closed after a refusal.
Right. This judicial approach offers a vital avenue, a second wind almost, for applicants to continue their pursuit of patent protection by addressing specific objections through strategic amendments, rather than facing an outright final rejection based only on the initial claims.
It's like that chef example you mentioned earlier.
Exactly. If the initial claim for any sweet dessert is too broad and gets rejected, this ruling confirms they can come back during the appeal and say, okay, fine, what about just the specific chocolate lava cake recipe? And potentially get that approved after re-examination. It's a pragmatic path forward for innovation.
And that right there is exactly what we aim for with the deep dive. We take these complex, sometimes frankly intimidating documents, like a high court judgment,
Definitely can be intimidating.
and distill them into focused, clear, and hopefully actionable knowledge. It's about giving you that shortcut to being truly well-informed without having to wade through all the legal intricacies yourself.
And maybe sparking some thought. For instance, given this flexibility in amendments and the judicial willingness to facilitate a fresh review, what does this imply about the ongoing dialogue between patent applicants and the Patent Office? How does it balance encouraging innovation with maintaining clear legal boundaries?
That's a great question.
How might this shape future patent strategies for inventors and companies operating in India? It's certainly a dynamic landscape, and this ruling adds another layer to it.
Absolutely. It's a fascinating area to consider. Food for thought. Thank you for joining us on this deep dive today. We hope you feel more confident and informed about the nuances of patent law and how strategic legal moves can really impact the journey of an invention.
Hope it was useful.
Keep exploring, keep questioning, and don't hesitate to send in your sources for future deep dives. We love seeing what you're curious about. Until next time, keep digging.